everyone. If you can hear me, let me know. I am in my office, not in my usual place, but we have some bad news, and I do have an update. I talked to Matt LaRosiere late last night, and got a comment for you guys. So we're going to get into what is going on. This is California taking on the catalog, and this is Control Pew fighting back in Florida. And what exactly happened? I see CRS Firearms out there. What is up, CRS? How are you doing? The document, this document is in the description. So if you guys wanted to take a look later on, you can after that. But we're going to get right into it. I am joined by Flying Rich. How are you doing, Rich?
Crumpy, just watching the world burn.
Of course, the world always burns. There's nothing different about that. But we are going to get into this right away. We're not going to waste any of your time out there. So we're going to get into this right here. I'm going to go ahead and bring down the comments for right now, so Rich can have a better chance of winning. But first, before we get into this, let's go ahead and talk about what is going on with this. Okay, California sued Catalog in state court for violating the California law, stating that they are making their files available to people out in California, and California bans 3D printed files. The catalog is located in Florida, and oh wow, he's up.
What's up, homeboy?
It's in Florida, and they don't really operate in California, but California decided to sue them in state court. Anyway, so we're going to just get into this because what happened is Control Pew sued California to try to get a temporary restraining order against their actions in federal court. And we have a ruling back from the judge here.
So what court was this? Was this some district court?
This is a district court in Florida, yeah. So, Rich, start reading.
This cause comes before the court on Plaintiffs Control Pew LLC, Alexander Holiday, collectively the plaintiff's motion for temporary restraining order. The motion, the court does not deem a response to the motion from the defendants, David CHUI, San Francisco attorney, and Rob Bonta, attorney general of California, collectively the defendants, to be necessary. Upon consideration, plaintiff's motion is due to be denied. Whoa. I thought that was a slam dunk. Background: Alexander Holiday is the manager of Control Pew LLC, a company that publishes on the internet written guides, photographs, and digital design files, including 3D models for the production of 3D printed firearms, otherwise known as ghost guns. Ooh. Both plaintiffs are located in Orlando, Florida. Defendants Rob Bonta and Attorney General of California and David CHUI, the city attorney of San Francisco, seek to enforce California Civil Code, the ghost gun ban, which prohibit the distribution of any digital firearm manufacturing code to any other person in the state who is not federally licensed firearms manufacturer, member of the armed forces, while on duty and acting within the scope and course of employment or law enforcement agency or forensic laboratory.
Yeah, you can skip all the rest. Dark, take over.
Very gay. Very.
Oh, by the way, Minton State Media, happy birthday, bud.
Yeah, happy birthday. All right, we're starting in plaintiffs.
Yeah.
Plaintiffs bring this pre-enforcement action for declaratory and injunctive relief, seeking to enjoin defendants from enforcing California's ghost gun ban against plaintiffs. The complainant levies 4 cases of action against defendants. 1. Enforcement of the ghost gun ban against plaintiffs constitutes an unconstitutional, quote, prior restraint on speech, which it's definitely part of, speech expression, which is protected. 2, the the extraterritorial application of the ghost gun law to plaintiffs violates the due process clause of the Constitution. 3, the extraterritorial, am I saying that right? Extraterritorial?
Yeah.
Application of the ghost gun ban to plaintiffs violates the dormant commerce clause of the Constitution. And 4, the application of the ghost gun ban to plaintiffs violates the Second Amendment to the Constitution. Facts.
All right, Rich.
Legal standard. To obtain a temporary restraining order, a plaintiff must show 1, a substantial likelihood of success on the merits of the underlying case, 2, irreparable harm in the absence of a restraining order, that the harm suffered by plaintiff in the absence of a restraining order would exceed the harm suffered by the defendants if the restraining order was issued. That restraining order would not deserve the public interest, Johnson Johnson, blah. And further, temporary restraining orders are extraordinary and drastic remedies. You got to scroll up. Crump, quit writing your book.
He's playing Call of Duty.
Not to be
No,
granted
I'm not.
unless
I'm
the
actually
movement clearly establishes the burden of persuasion to each of the 4 prerequisites. I'm skipping all the legal cases. Ultimately, issuing a temporary restraining order should be the exception rather than the rule.
Discussion. This case seemingly presents several issues of first impression in the 11th Circuit. Accordingly, after an expedited review of the limited briefing on these novel issues, just kidding, the court determines that plaintiffs have failed to clearly establish the first requirement for proving entitlement to a temporary restraining order. Namely, the plaintiffs have not demonstrated a substantial likelihood of success on the merits. Case law. Importantly, the motion only raises arguments as to counts 1, 2, and 3.
Rich.
While the complaint and motion simply assert that the computer code downloaded by the plaintiff's customers is speech, in reality, this issue has been sparsely addressed by federal courts and is a question of first impression in the 11th Circuit. Ouch. Let's see. At this juncture, the court finds the Third Circuit's framing in defense distributed to be persuasive. Ouch. In defense distributed, authored just 2 weeks ago, the Third Circuit analyzed whether an attempt by the Attorney General of New Jersey to enforce a criminal ghost gun ban violated the First Amendment. Defense distributed, blah. As part of relevant analysis, the court grappled with whether the computer code used to print ghost guns qualified as First Amendment protected speech. The Third Circuit held that computer code can be covered by the First Amendment, but coverage cannot be assumed because code is inherently functional.
Basically, what that means is they saying that the circuit court said that if code only instructs a machine to do something, that it's not protected under the First Amendment because it's not expressive, it's functional. And they made some new rule which has never, ever been used anywhere else.
This is absolutely trash. I'm sorry, Rich, real quick.
Yeah.
First off, I just want to say that if someone chooses to express themselves by artwork, which happens to be, computer aided design, and it's a functional item, if that code gets out because the person is expressing themselves, which is, in my opinion, protected activities, why when it changes hands or is out on the internet, is it no longer protected?
I don't know.
It's absolutely absurd.
They made up a new rule so they could rule against defense distributed.
Was it the Fifth Circuit decided the opposite?
Oh well, a bunch of different courts. The Supreme Court decided the opposite.
So you could go back to the I forgot the case. It's in the 60s. In the courtroom, Vietnam era, guy with the jacket that had obscenities on it that was charged. It literally set Supreme Court precedents.
Yeah, but they're saying that's expressive and code is purely functional.
Are jackets not functional and expressive?
Well, they're saying that the stuff in there is expressive. What the Third Circuit said is because code is purely functional, it's not expressive because it's not communicating to a person; it's communicating to a machine.
But
So
the
I
act of
think
designing it is an expression.
Yeah, I'm just
I
saying
know.
what they
right,
I know.
argue.
right.
I
I
know.
think
I
they
know
had
you're
a
not arguing.
decision already made up and then came up with a reason to support their decision.
Yeah, let's
Yeah.
keep on reading though.
Importantly, the determination of whether code enjoys First Amendment protection requires a fact based and context specific analysis. Critical to this analysis is the technical nature of the code, source code, or object code, and how the code is used in context. Precisely how the writer or user of the code might interact with the code, who is communicating through the code, and the intended recipient of the communication, programmer to human communication, human to machine communication, and so forth. For the purpose or purposes, the computer code operates to perform a function to express an idea or some combination thereof, and what, if anything, the code communicates. Fatally, neither the complaint nor motion contains facts sufficient for the court to apply these factors. The complaint and motion hardly describe the nature of the code itself or how customers interact with the code. As a result, the plaintiffs fail to demonstrate the likelihood of success on the merits to count one.
Dark takeover.
Yeah. Next, plaintiffs raise. I'm sorry, I'm a little nasally. Sinuses. Next, plaintiffs raise a dormant commerce clause and due process challenge. State laws that discriminate against interstate commerce face a virtually per se rule of invalidity. There's case law cited. This per se invalidity is triggered when a state mandates differential treatment of in state and out of state economic interests that benefits the former and burdens the latter. The court found that Michigan violated this constitutional provision when it permitted in state wineries to ship directly to consumers, subject only to a licensing agreement, but mandated that out of state wineries, even if licensed, go through a wholesaler and retailer. Yet the California ghost gun ban does not discriminate against sister state commerce like Michigan's scheme in Granholm. In this case, California's ghost gun ban does not favor in state ghost gun manufacturers or sellers. I don't know anyone in this case that's a ghost gun manufacturer or seller, but I digress. Rather, this case presents an attempt by California to prohibit the sale or manufacture of ghost guns inside of its own borders by anyone, regardless of in-state or out-of-state statutes. Status. Sorry. Go ahead, Rich.
Oh, yeah, I was just going to put a nasty comment. The ghost gun ban is a classic example of the exercise of state police power and moral judgment. As the Supreme Court has recently clarified, a state may exclude from its territory any articles which it, in its judgment, are prejudicial to the interests of its citizens. I don't know if that's national pork.
Don't worry about it. It's a national pork producer.
Okay. In Ross, the
Council.
court held that a California law prohibiting the sale of pork derived from pigs in breeding pens did not offend the Dormant Commerce Clause. The upshot was that regulations applying equally to both in-state and out-of-state producers do not offend the Constitution. California's law does not advantage in-state firms or disadvantage out-of-state rivals. Here, the ghost gun ban is a mere exercise of state judgment that ghost guns are prejudicial to the interests of its citizens and must be regulated. The regulation applies equally to those operating in state and those operating out of state, according to the plaintiffs, are unlikely to succeed on the merits of their dormant commerce clause or due process challenges. As a result, plaintiffs have failed to demonstrate the substantial likelihood of success on the merits of any of their causes of action. Whoa!
Yikes.
For the aforementioned reasons, plaintiff's motion for temporary restraining order is denied. Done in order in Orlando, Florida, and that is signed by Paul Bryan.
All right, so I've got a couple of comments on this. So first off, if you publish
Okay.
something,
Before we get into that, I want to give I want to give the quote that I got before. Then we'll
okay.
get into all that. Okay, that's what I was pulling up when you accused me of writing a book.
I thought you were playing Call of Duty.
Matt Larossiere, who was the attorney for Control-Pew, gave me a quote. He said, "We are very disappointed. This ruling is not substantive and ignored that we identify what type of works are at issue. We will be amending the complaint and moving for a preliminary injunction next."
Okay.
All right.
Before you get into that, I also want to state Paul Bryan. Guess who appointed him?
Obama.
Yes. He's an Obama appointee, so there you go.
Of course.
All right. So Matt said he's going to be moving for a preliminary injunction.
Yeah, preliminary injunction, so they can amend the complaint and move for a preliminary injunction. They went for a TRO.
I mean, if you don't get the TRO, chances of you getting the preliminary injunction aren't so good.
Yeah, on the same complaint, but they're going to amend the complaint.
Okay, and I guess maybe the amendment would address these issues better, so you're getting a second bite of the apple. But here's my problem. And again, it seems like the court in New Jersey that decided they didn't believe computer code was speech and wasn't protected speech, even though the Supreme Court decided differently. I think they came up with a decision and made up reasons to support that.
Yeah, they made a new test. They 100% made a new test. And I don't believe
Larossiere said, "Hey, you're treating me different than ghost gun peoples in California. That Florida ghost gun peoples are treated different." So the first issue here is that's not what they said. They said, "Who the hell are you in California to apply your laws to me, a Florida citizen?"
Correct.
So the court just said, let's find a reason to moot this, and we'll make ish up to make it sound legal and right.
It's the same idea as show me the man, I'll show you the crime, right? Like it's
pretty much.
They came up with the conclusion that they desired, and then they found a way to,
But how is this? And again, I got to go back to that computer code is speech, and the Supreme Court has said such that this is now, I forget the proper legal term, but this is quelling free speech in Florida because of a California frickin' law.
It's like chilling free speech.
Thank you. This is chilling free speech in Florida by Florida men that want to communicate. If anyone is creating the crime, the criminals, and I'm saying this as a devil's advocate, the criminals in California's eyes are the people downloading the code. If you publish it, freedom of speech, look at the Pentagon Papers, where when you talk about things, that is freedom of speech, period.
Well, Pentagon Papers saved our ass in Florida, Rich.
Yeah, I mean, isn't there actual Supreme Court precedents set specifically on when something is, like if it's just a CAD file versus actual G code on an SD card versus a sliced file versus isn't there actual court precedents set on that specifically from defense distributed or deterrence to, from one of the DD's cases?
Yeah, but the third, it was also out of the third. So the third, it's not a circuit split or anything because the new test came out of the third as well.
So help me understand this, okay? And I think people out there may have similar questions. I guess initially my question would be this: so if me, you know, doing some form of art, right? That's an expression. If my art form is drawing things in, you know, computer animated design, computer assisted design, whatever, then that's purely an expression. But how, if the expression is me drawing and coming up with things that are functional or whatever, if that is an expression, but the result, the end item, the code that it could be functional, how are those two things differentiated? It's like saying you painting a canvas is totally covered, but once that canvas is complete and can be, you know, given to someone else, no, 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 no.
Well, they are saying something slightly different.
Yeah,
Well,
they're
yeah,
not.
yeah, yeah. Well, so what I'm talking about though is that I don't understand how it's not protected. I'm just saying, like, that's how I'm thinking of it in my mind. Not that they are saying this. I'm just saying that I
Well,
think it's protected
and again,
expression.
this kind of reminds me of the Matt Hoover case, CRS Firearms with the auto key card. It is a business card, you know, with some diagram on it. A lightning link? Is it a machine gun? Is it a, you know, expression of speech? And you are the criminal if you make it into an auto sear. You know
Polar
that.
Knights. You should see the rest of my guns, Polar Knights.
But I'm baffled. So the code, the STL file, in my mind, is freedom of speech. Certainly, the
Agreed.
instructions on how to do it is freedom of speech,
Agreed.
and any of the guides, the descriptions, pictures, photographs is freedom of speech. If you take that and then manufacture something that's illegal in California, that's or download it, which I think is ridiculous,
Oh,
but then possessing the STL file. Actually, I'll hold up my defense distributed thumb drive. Possessing the computer code to manufacture the firearm in California by their bogus laws. If that's illegal, then the person, or in California's eyes, the perp in California is the criminal. Because if I don't know how many states I can download an STL file for a firearm, or, you know, G code to cut and mill CNC firearms. I don't know how many states that's legal in, but you're quelling and quashing the speech that's legal in other states, which
well,
is crazy.
no,
Yeah.
I want to take it a step further. I want to go back to the Third Circuit decision in Defense Distributed. If they're saying that code that tells a computer something is not protected by, don't have any protections, right?
Well, it's
Hold on,
interesting.
Rich. Let me finish my my thought. Okay, so the work that Fryout does on his AR designs
Mhm.
wouldn't be protected. Not only that, but if it's not protected at all because it's computer code, it just tells the machine to do. Uh, the code that makes cars, because it's all cut out, that wouldn't be protected either. So that means basically nothing's protected.
That was kind of
So
my point about the expression point. Sorry, Rich. I know you were trying to talk. Just saying the idea, like in my head, of Frag Out Firearms, Frag Out Design Studios, shout out, him hand drawing everything and then uploading it to code essentially to the laser to put his hand drawn, you know, engravings on a firearm. It's the same thing to me as someone sitting down like Hoffman Tactical catting out super safety or the Orca, or like what's the difference? I don't see a difference in that.
Yeah, William Tardy brings up a good point, and I was going to bring this up as well. He talks about the Ninth Circuit. The Ninth Circuit had an encryption case where they tried to ban encryption, but they determined that it does have First Amendment protections. So one of the interesting things in the defense distributed case and the Ninth Circuit case, which is the reason why I was going to bring it up, is because it kind of created a circuit split.
So they didn't say in rebutting this or disapproving the temporary injunction, they didn't say that code that speaks to a machine, human to machine code, if it produces something illegal, they just said human to machine code isn't protected.
It said it's not. They didn't say that it's not protected. Yeah, there is a case out of the six. There's actually several cases. They didn't specifically say it's not protected. What they said, it basically it's on a case by case basis.
Okay.
It's not presumably protected because you got the presumption of code being protected.
So, okay,
the Third Circuit said it's not. You can't presume that it's protected.
So
they didn't
theoretically, if it's CNC to build a engine block or cylinder head or something like that, that could be considered protected.
It could be. It's basically on a holistic case by case basis, which gives a lot of wiggle room. I hate that whenever there's ambiguity, whatever, Rich.
Ambiguity.
Wherever that rears its ugly head, that's where it usually run into problems, because then you're leaving it up to people to decide what they like and what they don't like. And to me, I think that is the antithesis of the First Amendment, because the First Amendment is not about protecting popular speech; it's about protecting unpopular speech.
Yeah.
Now you're going to give a judge the ability to look at it and go, well, I don't like that, so it's not protected.
Yeah.
And I think that's exactly what the defense distributed decision did. And I'm disappointed, even though I'm not surprised because of who the judge is. Paul Byron. Paul Byron is no friend to guns. Obama appointee, of course. So he's going to use any way necessary to prevent this TRO. And I don't think he did it because of a legal standpoint. I think he did it because of a philosophical and an ideological standpoint more than a legal standpoint. And that's not good. One of the advantages of autism is you can separate emotion and ideological stuff from legal stuff.
If I shoot video of myself jaywalking in Florida and somebody in California watches it and thinks they should jaywalk also because I did it, am I guilty of jaywalking in California?
Straight to jail.
Well, if they no, it's a little bit different because they would have to have a law that says you're not allowed to show people how to jaywalk.
But wouldn't that be like collusion or conspiracy or something like that?
You know what? Honestly, who knows at this point?
Structuring.
Structuring.
One of my favorite crimes.
Yeah. The crime that you can always and never commit.
By the way,
I take $9,000 out today and tomorrow of the bank, I'm guilty of structuring. But if I take $10,001 out today and tomorrow, I'm not guilty of structuring. How about that?
An EPS 32. I wonder what I'm building with that.
ESP 32?
Yeah, ESP 32. Sorry.
Ugh. I knew someone with ESP.
Mm-hmm. Yeah. So yeah, it's definitely interesting, and I don't think that this judge actually looked at the legal facts. I think he had a predetermined conclusion that he was going to come to no matter what.
Yeah.
And he looked for something. He looked at the third, because he could have also looked to the sixth or the ninth and said, no, these other two court, the majority, but he picked the outlier instead of picking, the other cases that all say something totally different. He chose the outlier to come up with his decision, which usually isn't good.
What process selected this judge?
Very good.
What's up?
What process selected this judge?
What do you mean?
How did this fall upon him?
It's like a random round robin type thing.
Sure.
So it's like spin the bottle. I hate to say it. So Larossier in a well written legal brief.
Larosière.
I'll say however I want.
I always
Got a
I
problem
call him
with
Larossier.
He knows my address.
It sounds like Cavassier. So
Yeah, we actually called him on to like asked him go on the
Hey,
record
if
of how you
Stambolier
pronounce
doesn't
his name.
care how I say it, I don't know what Larossier's got a problem with.
yeah. Hey guys, I gotta get back to the little one. I just saw you pop on, so I just want to come on and say hi. But
Yeah, we're gonna wrap up in a couple minutes here anyway.
okay, well, we are doing the live show on DLD After Dark on Rumble tonight, every Tuesday, Thursday, Saturday at 10:30 p.m. Eastern. So check it out.
Later.
And you're joined by Josh from Black Diamond Guns and Gear tonight.
Yep, correct.
Oh, cool.
And
Did you see my Twitter post?
I did not. No.
Oh, guys should look at it because it's definitely interesting.
So humble.
No, I think you'll like it. It talks about
Stromboli man and rotisserie man. That's good.
it talks about I'll just throw it up really quick just to show you, just because I think you might find it interesting. About somebody admitting to using DMT and other psychedelics.
I heard about that, and it almost sounds like they were an active user, like they would be considered an unlawful user and or addicted to.
Yeah, if what he's talking about is I just go to my ex Crumpy SS on Twitter or X, whatever you want to call it.
There's a form you got to fill out that I remember.
4473. Yes.
That's what it is. Yeah.
But I don't know. My bigger question is, like, I get cluster headaches, and one of the reasons that I don't take one of the treatments is psilocybin.
Yeah.
And it's like extremely effective. Like extremely, like you take it, it's like 99% of the people who get cluster headaches won't get another cluster headaches for like 6 months. But the reason why I haven't done it is, well, maybe the new rule, but under the old rule, that you take it, you're done for a year, and you lose gun rates for a year. And if I fill out a 4470, I think I'll buy a lot of guns.
Let me just
go on the record. It would be a felony. I
do want to say, I'm just going to go on the record that I think anyone should be able to purchase any.
Yeah, so do I. But no, my question is more of from the cluster headache standpoint.
Yeah, so I think it's different with medical, certain medical things, but
not Schedule 1.
Yeah,
that's why you can't. That's why medical marijuana cards.
Yeah, no, I'm
Schedule 1. It's done. It doesn't matter. There's Schedule 1. Doesn't matter.
Yeah, I'm saying my opinion is that it's different.
100%.
Yeah, not that like I'm saying
100%. No, I'm just wondering my closer.
Yeah, but trust your federal government. Yeah. So, do you want to touch on that a little more? Explain who you're referring to in that
list. It's Lawrence DeMonico.
Lawrence DeMonico. So Lawrence DeMonico was actively using drugs and then filling out federal forms for,
I don't know,
equipment, maybe.
I don't know. I don't know.
When I took mushrooms, I never had any headaches.
Do you usually get headaches?
I mean, every now and then.
No, I don't know. I don't know, but
I really don't remember.
Yeah.
Because the mushrooms. I'm just kidding. I think drugs are bad. Okay.
Yeah. All right, guys. But I think we're pretty much done here. I mean, that's all. There's another story out there about There's another story out there. ADD and ADHD meds do not count because they weren't Schedule 1.
Which is crazy because it's literal methamphetamines.
Yeah. but it's not Schedule 1. But yeah, there is another story out there, and there's another lawsuit that I was going to cover today, but I'll cover that tomorrow. And that is a new lawsuit challenging the NFA that is out of Kentucky, filed by FPC and ASA, American Suppressor Association. I do have an article that might be up now on it, but we're going to get into that probably tomorrow sometime. I just don't feel like doing it right now.
All good.
And Rich, I do have a question. Florida HB 133 failed.
Okay. 133, was that some gun grabbing law?
Restore purchase rights to young
Felons?
adults.
Oh,
So 18 to 20-year-olds still cannot buy rifles.
wow.
Like certain rifles, like semi-automatic rifles. The Senate
You get a
blocked it.
bolt gun.
Republicans in the Senate blocked it.
Rhinos. All Democrats are Democrats, and most Republicans are Democrats.
Yep. We need to start a new, a completely separate party, the Christian Constitutionalists, and change the world.
Yeah, but we're talking about like back like before it was rescheduled. That's why medical marijuana, you couldn't have that. Whatever. It's all good.
I'm not sure what toothpick you're referring to, Polar Knights. Sorry.
But we are going to get out of here. Thank you so much for watching. Check out Definition Knives, by the way.
Thank you. Actually, I will say, if you go to definitionknives.com, you'll see that all of our knives are under $100, and the 3 that we currently have in stock are actually all $59 to $79, all very high quality, either D2 tool steel, 8CR13 MOV, really good quality stuff. And we still got co-pilots in stock, blue hardware, carbon fiber, gorgeous bayonet swedge on the back of the blade.
I still like the DK1, my favorite.
I have one. They're out of stock. I personally have one, and that's it. I love when Rich has his green screen on and he tries to show stuff, and it just always disappears.
Yeah. And
technology.
So we're going to get out of here. Thank you guys so much for watching. Like I said, we'll cover the other stuff maybe tomorrow, maybe Monday. I don't know when, but we will definitely cover it. There's a lot that's happening out there. It's been crazy. And yep.
Very cool.
There you go.
Wow, very cool. That's super kind of you, Polar Knights. Thank you.
Polar Knights is from Norway, right?
Yep.
All right. We're out of here, guys. See you later. Bye.